A core principle that runs through the Constitution's provisions and lies at the heart of democracy itself is the notion of liberty. At its simplest, liberty means the right to be free from oppressive government restrictions on your way of life or your beliefs. And nowhere does this ideal feature more prominently than in our criminal justice system, where the threat to one's liberty is most acute, where freedom can quite literally be taken away by a government official, whether it's a police officer or a prosecutor or a judge or a president bent on retribution. The framers, having just freed themselves from British tyranny, understood the immense stakes involved when the state's security apparatus can be weaponized against ordinary citizens. According to my next guest, Rachel Barko, quote, American identity is inextricably linked with a commitment to liberty. Our founding documents are awash with paeans to freedom. Our constitutional republic is designed to put the brakes on government excess when it infringes on liberty. That is, after all, the central story of our country's founding and the reason we fought a revolution. These brakes on government power include several key constitutional safeguards that kick in during the criminal justice process, including the Fourth and Fifth Amendments. And these checks on police power are designed to protect civilians from unreasonable government searches and ensure due process for all, meaning that anyone accused of wrongdoing is guaranteed their day in court, at least in theory. Barko explains further, quote, the Constitution covers everything from investigation to punishment, and no wonder. Government power is most threatening in this context because it can strip away liberty and even take someone's life. The framers intended to make it hard for the government to criminally punish people because they feared that making it too easy would be a far graver threat to core individual rights and safety. Despite the framers' good intentions, politicians in later generations have chipped away at these constitutional safeguards, often using public safety concerns as a justification. By playing on fear, they've convinced the public to get on board with more intrusive government actions, like stop and frisk and racial profiling and pretrial detention. And many times, they get away with this erosion of rights by scapegoating less sympathetic groups, often using minorities and immigrants as bogeymen to justify crackdowns on rights. But once you consent to the reduction of freedom for one community, you've effectively consented to less freedom for all Americans. And just because you're not the target today doesn't mean you won't be the target tomorrow. Generations of Americans have seen this play out in tragic ways, from the Chinese Exclusion Acts to Japanese internment camps, from the Red Scare to the War on Terror. And it's also evident in everyday police interactions in Black and brown communities, where broken windows policing promises that enforcement of low-level crimes will create a safer environment and deter more serious crimes. But in practice, the broken windows approach has actually led to over-policing, racial bias, and tensions between police and the communities that they serve. This regression in rights may have been fueled by political rhetoric, but as Barko argues, it was cemented into law by none other than the Supreme Court. She writes, quote, the Supreme Court, starting in the 1960s, decided a series of cases that eviscerated the constitutional rights that were supposed to safeguard against government oppression through criminal punishment. These cases can be defended only under a constitutional theory grounded in pathological deference to the government and its claims that liberty must be sacrificed for public safety. That, however, is less a constitutional theory of interpretation than it is pure politics. Now, here's what the framers understood and what they feared the most. Once the groundwork for anti-democratic measures is laid, once it becomes easier for the state to scale back rights and harass civilians, you're only a few steps away from an autocrat stepping in and exploiting those vulnerabilities. And given what this country has witnessed in just the last 2 months, there seems to be every reason to be alarmed right now. In less than 100 days, President Trump has threatened to punish American universities that don't conform to his agenda. He has, without basis, called the work of journalists illegal. He has targeted law firms linked to Democratic figures and prior investigations against him. His administration has deployed masked agents to arrest students with otherwise valid green cards and visas. The Trump administration has also flouted judges' orders, including apparently one barring him from deporting hundreds of immigrants under an obscure 18th century law, claiming without proof that all of those migrants deported are gang members. The same law was last used to justify the internment of Japanese American civilians during World War II, an episode now recognized as among the most shameful chapters in our history. And as protests against his administration intensify, the president has threatened to prosecute some of these protesters as terrorists. In other words, Donald Trump may actually represent the very kind of tyrant the framers feared most when they established checks on government power and when they warned future generations not to sacrifice essential liberty for a little temporary safety. As Barco notes, quote, "We should be just as committed as the framers were to making sure the government stays in check. The problem is the Constitution cannot protect itself." I'm joined now by Rachel Barco herself. She is a law professor and my colleague at NYU School of Law, and she is also the author of the book from which I just quoted, Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. Welcome.
Thank you.
So the book focuses on mass incarceration and how all of these assaults on liberty have facilitated mass incarceration. But you also note that there are more, I think, quotidian assaults on freedom, and we're seeing them right now. So can you connect the book to this particular moment where we're seeing all of these assaults on constitutional rights?
Yeah, I think it all stems from the fact that once you get a public that's scared enough, afraid of something, whether it's crime, whether it's immigration, it's very easy to convince the public that you need to have the Constitution's protections give way a little bit in order for what seems like protection. So, in the book I talk about, for example, the idea of someone's arrested, they should be detained pre-trial if we think they're a danger. Never before in 200 years did we think dangerousness was a ground for detaining someone just because of an arrest. But the court ends up approving it, basically because of a concern that otherwise crime would be too rampant. And I think you see the parallel today in how people talk about immigration and immigrants and the idea that we're going to deport people because we think they're members of gangs. They get no due process. There is no hearing to make sure we have the right people. Right. They're just sent away. And I think you get a public that is receptive to that only if you first have them scared enough that they think, well, we have to do something. We have to cut constitutional corners.
One of the things you emphasize in the book is that the court has exhibited an unusual amount of deference to the government when the government touts these concerns about public safety and national security. And right now we are seeing a number of these lawsuits work their way through the court where the government is now saying, we can't tell you that or we can't talk about that because state secrets and national security. What's your fear about how the courts are going to react given their prior history here?
Yeah, I am afraid, to be honest with you, because I think there's this sort of presumption that the government acts in good faith and there's, regular processes and, good faith actors are working there. And I think there's a concern that the court will just say, hey, it's not our lane. You elected this person as president, and we're going to let that person kind of take charge. The one thing that makes me a little bit more optimistic is I think that this administration has so blatantly showed disregard for law, for regular process, for courts, that it may be they have pushed that assumption to a point where the courts have to second guess it and say, do we really want to give this guy that same presumption of regularity and good faith? And the hope is that maybe he's gone so far that courts will actually take a closer look than they otherwise might have.
Well, one of the fears here, too, though, is the public gets on board with this. The public wants public safety. Judge Patricia Millett, in one of those hearings on the Alien Enemies Act and the deportation of those so-called Venezuelan gang members, noted that this country has actually given more due process protections to accused Nazis than we have to individuals who may not actually be Venezuelan gang members. And she worries that if they can do that to those people, it's only a short leap before they're able to do that to other Americans, including American citizens. Is that true? Is that where we're headed? And could those processes be taken away for all of us?
Yeah, if tomorrow they were to detain someone and ship them off to El Salvador who turned out to be an American citizen, right now they're claiming in court we can't get that person back. They had someone who was lawfully in the United States. Mr.
Garcia, who is the Maryland father who has been improperly deported.
Yeah, and they're saying, we made a mistake, but it's too late now and we can't get him back. If that same thing had happened and it was an American citizen who had been deported, it'd be the same argument. They would say, well, we made the mistake, but it's too late. We can't do anything about it. And so I do think people need to understand this isn't just a threat against people who are immigrants or might not have lawful status. It really is all of us, because without due process, there is no guarantee that you have the right people and that you're imposing the right consequences. You need to have an opportunity to be heard, give these people notice, and a right to their day before a tribunal to make sure that this is an accurate decision.
All right. That is Rachel Barco. She is the author of the new book, Justice Abandoned: How the Supreme Court Abandoned the Constitution and Facilitated Mass Incarceration. It is an urgent read for right now. Thank you.
Thank you.